Prime Minister Dr. Keith Rowley has instructed the Attorney General to let the 30-day Freedom of Information Act time limit for response stand as is. Dr. Rowley announced the decision during his contribution to the debate on the Miscellaneous Provisions Bill 2019 in the House of Representatives today. Over 40 groups, including the opposition, were against Clause 7 of the bill, which seeks to increase the length of time any public institution or state agency has to respond to a request for information made by a member of the public. The period would be extended from 30 to 90 days, and the AG would have been able to authorize a further 90 days.
As head of the government, I'm instructing the Attorney General, let the 30 days stand. Right? Let the 30 days stand. Because that is not the primary objective here. The primary objective here is to prevent the loophole where lawyers dig out taxpayers' eye, and that stands. The government stands with that. That's what we came here for. We came here to prevent the Attorney General from being in the dark.
Dr. Rowley explained that the amendment, which gives the AG an opportunity to be informed of the request, is the only way that the public interest can be preserved.
Today, the opposition leader argued that the entity must be allowed to stand on its decision without let or hindrance. That might be so in law, but in terms of who is paying the taxpayer, that don't make no sense. Because if you could avoid the lawsuit and the legal fees by simply providing the information, why do you want to keep the loophole so the lawyer could sue on the rejection and then come and milk $1 million?
Opposition leader Kamal Prasad Bisesa said the amendment gives the AG the authority to grant approval before a final decision is made, and she said that cannot be right in the law. She said she looked at 125 countries with FOIAs, and not one of them has the AG inserted into the legislation.
The AG is telling us, don't worry, I am just going to say yea or nay. When they said it to me after they said yes, I will review it, and I could change my mind. I could say yes, give it to them. Or he could repeat the no. Well, that may be all and well and good for the Office of the Prime Minister, for the Minister of Finance, Minister of National Security, and so on.
But she said institutions like the Parliament should not be directed to the AG when it comes to the approval of requests.
So if the Parliament said, no, I'm not giving it to you, AG, what do you say now? He's not like the final arbiter, like a court of one jurisdiction, own jurisdiction. Parliament, and they send back here to tell this Parliament, madam, you have to give it to them. That cannot be right in the law. You see, it cannot be right in the law.